My name is Fleur Kingham. I'm Chair of the Queensland Law Reform Commission, and I'm here with one of our commissioners, Ms. Avelina Tarrago, a Wonkamadla woman and barrister, and we're wanting to talk to you about a review that we're conducting into the processes for mining approvals, mining leases and environmental authorities. We have published 2 consultation papers and a number of background papers already in this review. And what we're addressing today is the feedback that we've had from a really extensive consultation process. We have, in our consultation papers, we put out 6 consultation proposals to get feedback on, and we're about to publish our 4th background paper, and that summarises your thoughts on the reimagined process for approving mining leases and environmental authorities. We're really grateful for those of you who have shared your views with us, whether formally or in meetings. And we received 39 written submissions from a range of stakeholders. But it wasn't just written submissions, was it, Av?
No, so in addition to those submissions that we received, we're also able to engage with communities across Queensland, and that included places like Emerald, Mount Isa, Townsville, Burketown and Hopevale, and it was a great opportunity to be able to meet with people face to face and understand your experiences, in addition to receiving those written submissions. And we're also able to meet with some people who might not otherwise have been able to engage in the review. And so we encourage you to continue to share your feedback with us throughout this process.
I just want to draw out some key themes that are apparent to us from your feedback. Firstly, there's really strong support from most of you for changing the Land Court's role by removing the current objections hearing, which happens prior to decision, and introducing a combined merits and judicial review post-decision. Those who support the process think it will simplify and streamline the process. It brings the Land Court's role into line with other jurisdictions, and it supports meaningful participation. But some concerns were raised about the role of the court and whether the court, rather than elected government officials, would ultimately make the decision on the applications. And others noted concerns about the consequences of removing the objections hearing for private and communal interests, such as a right to compensation. Most of you said that standing to seek review should be restricted to those who have engaged in the participation process prior to the decision being made, with some limited exceptions. And there was strong support to establish a central online government portal which would give public notice and provide up-to-date information about proposals, but maintaining other forms of notice that many of you said you thought that should continue to be provided.
And some of the proposals were also designed specifically for providing greater opportunities for Aboriginal peoples and Torres Strait Islander peoples, and this was through our proposals to establish an Aboriginal and Torres Strait Islander advisory committee, and also amending the statutory criteria to require decision makers to consider the rights and interests of Aboriginal peoples and Torres Strait Islander peoples, their land, culture and cultural heritage. And so while we received general support for these proposals, there were some matters raised that concern some community members about the potential for overlapping, particularly with existing laws around native title and cultural heritage, and you know, just to ensuring that you're not creating duplication or uncertainty. We also heard particular views from community about the need to identify right people to speak for country, ensuring the rights associated with native title are respected, and ensuring Aboriginal peoples and Torres Strait Islander peoples who do not have a positive native title determination can genuinely participate in the process, and also supplementing any gaps for Aboriginal people and Torres Strait Islander people where the protections of the rights offered in native title and cultural heritage legislation might be lacking. Others recognise that our proposals might enhance the existing rights and extend those rights to individuals and groups who may otherwise be excluded from those processes.
A little like those proposals, with the consultation proposal about expert advice to decision makers, we had general support, but some mixed views about how that would work. So some told us that having an expert advisory panel to advise decision makers would increase the quality, consistency and transparency of decision making. But those who did not support the proposal told us it could increase uncertainty, time and costs, and undermine the existing expertise of government and industry. So those contrasting views and concerns are things that we'll be taking into account as we develop our recommendations.
So we also heard about issues that are created by other laws and processes that interact with the current processes. And for example, many of you expressed concerns about the siloing of mining and water approvals, and those of you viewed that the separation of these approvals as duplicative, and Aboriginal peoples and organisations were particularly concerned that the current process does not identify a holistic impact on water, or failing to adequately consider water rights, usage and its impacts.
So that's an overview of what you'll find in this background paper, which I encourage you to read if you have an interest in this review. Now we have our feedback. What's next for us? Well, we're moving to the next stage of our review. We've released another consultation paper looking at other resource production tenures such as gas and petroleum, and to consider whether our recommendations for mining should also apply to those processes. So we'll be conducting some more consultations and inviting submissions about that. We'll then move to the final stage of our review and develop our final report and recommendations, which we will provide to government by 30th of June next year, or 2025. So I want to say thank you to everyone who took the time to share their views with us. Consultation is central to our work, and we really value the opportunity to have ongoing, meaningful engagement with you. Your views are important, and they will help to inform the development of our final report and recommendations.